Imagine you are nearing the finish line on your real estate or business deal when suddenly the proverbial shit hits the fan and you realize that you're headed to litigation. Do you know what to expect if you have to sue someone or you find out you're about to be sued? I'm Paul Zimmer, a Wisconsin real estate attorney that helps southeastern Wisconsin individuals and businesses protect their real estate and business investments. Over the next few minutes, I'm going to share with you exactly what to expect when you are expecting a real estate or business-related lawsuit filed in the state of Wisconsin. The first thing I want to discuss is how litigation works. There are several steps to a lawsuit, and each step takes time. It's not going to be like on TV where 1 minute there's an issue, something happening, and boom, the next scene, the case is in a jury trial. Court cases take many months, sometimes years, to fully play out. Only about 1% of civil cases that are filed actually go all the way to a jury verdict. Most cases resolve in settlement, and sometimes cases resolved by the court on a motion, such as a motion to dismiss. Next, I'm going to go over step by step what to expect in a lawsuit in Wisconsin. Step 1, there's a complaint or an answer. This is the initial document that sets out the allegations in the case and the response to those allegations by each side to the lawsuit. So once the case is filed, very early on, the court will hold what's called a scheduling conference, at which point the attorneys and the judge will fill out a scheduling order that sets forth various deadlines of the various steps that need to take place in the case, which is what I'm about to explain next. Step 2, there's going to be a decision to decide whether to file a jury demand. Early in the case, the judge will set a deadline by which either side can file a jury demand asking that the case be tried to a jury. When you file the jury demand, you have to pay a small fee, either $36 for a 6-person jury or $72 for a 12-person jury. If nobody files a jury demand, then that means the case is going to go to trial by the judge. The next thing that's going to be ordered in the case is the plaintiff is going to have to file their witness list. This will be a deadline that the court will set by which the plaintiff has to spell out in writing who all the witnesses are that they're going to have called to testify. And if the plaintiff is going to use an expert witness, this is when the plaintiff has to set forth what that expert witness's report is. The next deadline on the scheduling order will typically be the defendant's witness list. This is where the court will set a deadline for when the defendants, or the parties who are being sued in the lawsuit, have to list all of their witnesses and all of their expert reports if they're going to use an expert witness. The court will also set a deadline by which any party can file a motion for summary judgment. A motion for summary judgment is where one party asks the judge to rule that that party wins the case as a matter of law without the need for a jury trial. In addition, the court will also set a deadline by which the parties have to conduct a mediation. A mediation is a settlement conference where the parties hire a neutral third party, such as a retired judge or an attorney who specializes in mediation, to try to broker a settlement between the two sides. Another date that'll be on the scheduling order is the deadline to complete discovery. So meanwhile, while all of the witness list deadlines are passing and other litigation is going on while the case is pending, either side can take discovery from the other side. So discovery would include things like asking written questions of the other side, asking the other side to admit or deny facts in writing, asking the other side to produce documentation or to produce inspections of property or things like that. Typically, the last date that'll be scheduled in your scheduling order is a pretrial conference. The pretrial conference typically requires, depending on the county, certain documents to be filed in advance of the pretrial conference, including things like a pretrial report, designation of exhibits that are going to be used at trial. At the pretrial conference, the judge will set a date for the trial. And the trial is when the parties will show up with their attorneys, with their evidence, and present their case. The plaintiff will go first and present their witnesses, each time with the defense lawyer having the opportunity to cross-examine those witnesses. And then when the plaintiff has rested, the defense puts on their case with their witnesses and vice versa. At the end, the parties make their closing arguments and the jury makes their decision whether or not you win or lose the case. The last step of the process is whoever loses the trial has the ability to file an appeal. And an appeal goes to the Wisconsin Court of Appeals, which is split into 4 different circuits based geographically around the state. So keep in mind that throughout the entire trial process, throughout the entire lawsuit, any party can file a motion at any time asking the judge for any type of relief that they want. Meaning, At any point, an attorney for one of the sides could ask for the court to order something with respect to discovery, to ask the court to dismiss the case or to rule on some issue in the case. And so for that reason, lawsuits and litigation can take a lot of different twists and turns because you just never know what the other side is going to argue and what you're going to have to respond to at the courthouse. So the important thing to keep in mind as you enter the lawsuit process is that it's all about balancing the costs and benefits and the risks and rewards of the litigation. You've got to think about how much each step is going to cost in terms of time and money, and whether you think that that next step increases your chance of a successful outcome at trial, and by how much. The most important thing you need to do is hire a law firm that is appropriate for your case so that you can be adequately guided through the process. If you need representation for a business or real estate lawsuit, visit our website for more information or check out the rest of our videos on our website and channel. So if you're expecting a lawsuit, feel free to give us a call and schedule an initial consultation, and we'll go over what we expect to happen in your lawsuit and give you our plan of attack for how we would prosecute or defend that case for you. I'm Paul Zimmer of Zimmer Rens, and we'll see you on the next video.